The intoxication defense. The intoxication defense is an excuse defense, and it asserts that the defendant should be relieved of criminal responsibility because he or she could not form the required mens rea due to severe intoxication that was involuntary or unknowingly induced. When intoxication was voluntary and knowingly induced, it does not necessarily eliminate criminal responsibility, but may mitigate, lessen, or diminish criminal responsibility in some cases. So let's make it clear. We're talking about two different intoxication situations. In both situations, the individual is severely intoxicated. In the first situation, it's voluntary intoxication. This person voluntarily, willingly drank too much or consumed drugs and got themselves severely intoxicated. This is different from involuntary intoxication or unknowing intoxication. In involuntary intoxication, somebody forces the person to drink too much, perhaps under threat of force. In unknowing induced intoxication, somebody slips somebody a drug and they take it without knowing it. Or perhaps they're taking a medication and have no way of knowing that it causes intoxication, and it does. That would be unknowing or involuntary intoxication. Now, let's first talk about voluntary intoxication and how the intoxication defense interacts with it. Voluntary intoxication will not provide a defense against a general intent crime, where the prosecution need only prove the defendant intended to commit the prohibited act and not its harmful consequence. For example, if an assault statute defined assault as causing intentional and harmful physical contact with another, an intoxicated person who punched another is guilty, even if he or she meant no harm, because the statute penalizes the act of physical contact. So as long as the intoxicated person knew that they were going to be hitting that person, regardless of whether they intended serious injury or not, they're guilty of the assault charge. But voluntary intoxication could provide a defense against a specific intent crime. And that's a crime where the prosecutor must also prove the defendant wanted the harmful result to occur. So a specific intent crime not only has the actus reus of causing unlawful, harmful contact, but there's an additional requirement in the law that you cause harm, maim or injure the person. So if the assault statute in the above example, which simply said if you intentionally cause physical contact, you're guilty of assault. If that also said that you had to cause that contact with intent to maim or disfigure, then the actor could escape liability under voluntary intoxication if the prosecutor could not prove such malicious intent, because the intoxicated state of the actor precluded such foresight of the consequences of the conduct. In other words, the intoxicated person, the person who became voluntarily intoxicated, knew that they were striking the person, but they were so drunk that they had no idea of the possible consequences of doing that. That would be a specific intent crime, and if they couldn't prove that second harmful result part of specific intent, that they did the actus reus to cause the harm, then they could use the intoxication defense to elude criminal responsibility. The intoxication defense involving involuntary or unknowing intoxication. Involuntary or unknowing intoxication is a defense that will relieve the actor of all criminal liability if the intoxication is so severe as to negate the mens rea or voluntary act provision of the law. Intoxication is involuntary when somebody forces another to drink or take an intoxicating substance against that person's will. And this often involves duress or coercion, threatening force if you don't drink or take the pill. Intoxication is unknowing in two situations. The first might be if somebody else sneaks a drug into somebody else's food or drink. In the old days, it used to be called slipping them a Mickey. The other way that intoxication could be unknowing is if a person knowingly takes a medication that causes intoxication, but was unaware of that side effect and would not reasonably know it. That's why when you get a prescription that has a narcotic drug in it, or anything that will cause intoxication or drowsiness, there's all sorts of labels all over the medication, and the pharmacist tells you, because they want to make sure that you don't unknowingly get behind the wheel of a car and be intoxicated and kill somebody. So that's the situation with respect to involuntary and unknowing intoxication. A person forced to drink to intoxication and then drive a car would not be guilty of DUI because they were coerced into doing both acts. Likewise, a person who takes medication that makes the person intoxicated is not guilty of DUI if they did not know it would cause intoxication, and a reasonable person would not know that type of thing. So those are situations when the intoxication defense relieves the person of all criminal liability. The mistake of law defense. Generally, ignorance of the law is no excuse because citizens are expected to know the law. Such knowledge of the law and illegality is easy with malum in se offenses. Remember, a malum in se offense is evil in itself. We all intuitively know that they are bad. Murder, rape, robbery, theft. But mistake of law defense also doesn't apply generally to mala prohibita offenses. And those are offenses that are not evil in themselves. They're only illegal because we make them illegal. Jaywalking, not carrying insurance for your motor vehicle. Those are not intuitively evil. Most people don't realize they're evil. So the fact that if you break those laws, you can't claim a mistake of law defense is a little unfair, but that's the way it is. Ignorance of a law is no excuse. You're expected to know the law. So I guess it's good that you're taking this law course. However, ignorance of a law is a defense if the ignorance is based upon reliance on a law that is later overturned, or upon misinformation from a government source, a person or publication that's charged with dispensing information about that law, and that person gives you bad information. So let's talk about an example of reliance on a law that is later overturned. Let's say that the voters in Arizona, using the initiative process, put on the ballot the legalization of recreational marijuana. And let's say that it passes. And then you go out and you start using recreational marijuana. And then let's say, and I'm just making this up, that the state Supreme Court rules the initiative illegal and basically takes away the legal marijuana law. Well, the fact that it was ruled unconstitutional would not make all of those who used marijuana before the court ruled it unconstitutional suddenly guilty of a crime. Because ignorance of a law is a defense if it's based upon reliance on a law, even if that law is later overturned. But by the way, kind of interesting with respect to marijuana, while that's true of state level enforcement, marijuana is still illegal at the federal level. So even if the states legalize marijuana for recreational or even medical use, it's still illegal at the federal level. And you could not use ignorance of the law or the fact that it's legal in the state as a defense if you were charged federally with a marijuana offense. Let's talk about the other situation, which is if you're misled by a government source. If you pick up a pamphlet at the Department of Motor Vehicles and it says that you have to have $10,000 automotive liability insurance, but that was a typo, you really need $50,000. I'm just making these figures up. And based upon the mistake, you only take out a policy for $10,000, and then somehow the police find out and they they charge you with uninsured driving. If you could bring that pamphlet to court, you would, in fact, be able to offer a successful mistake of law defense because you were misled about the law by a government source, a pamphlet, charged with dispensing information about that law, and it was wrong. Of course, once you find out it's wrong, then you have to comply with the law, and if you don't, you're guilty of a crime. In closing, let me also mention that an ignorance of law defense cannot be based upon advice from a private attorney. We're only talking about advice that you get from a government source, person, website, pamphlet that is wrong. If a private attorney gives you advice about a law and they're wrong, and based on that advice you wound up breaking a law, you cannot use the mistake of law defense. We can't rely on all the varying opinions of private attorneys, some of whom might not be too sharp and might make errors all the time. It would allow too many people to evade responsibility for breaking the law. And no doubt you'd have unscrupulous attorneys who would purposely give out bad advice for the right price to let people break the law. So an ignorance of a law defense cannot be based upon advice from a private attorney. The mistake of fact defense. A mistake of fact can relieve one of criminal liability if it eliminates the mens rea. However, because strict liability offenses have no mens rea requirement, a mistake of fact defense will not work with them. Here are some examples. A has lunch in a restaurant and hangs his coat up on a coat rack near the door. B enters 15 minutes later and hangs up his coat on the rack, and his coat is identical to A's. 30 minutes later, A exits and mistakenly takes B's coat. A could successfully assert a mistake of fact defense if charged with stealing B's coat, because it was a reasonable mistake. He thought he had his own coat. Here's another example, but this one involves a strict liability offense. B owns the above restaurant, and his refrigeration room thermometer malfunctions and incorrectly displays a temperature that is 10 degrees cooler than the real temperature is inside. Now, the law says that perishable food must be stored below 40 degrees, and the food in the refrigeration room is at an illegal 46 degrees because of the malfunction. But the bad thermometer erroneously displays a legal 36 degrees because it's 10 degrees off. So B thinks everything is okay, but a health inspector takes the refrigerator temperature and cites B for storing food at an unsafe high temperature. B cannot claim a mistake of fact defense because the food storage law is one of strict liability. It doesn't read, it is against the law to intentionally store food at a temperature above 40 degrees. No mens rea is required. It's a strict liability offense. It says that you break the law if you store food above 40 degrees. Storing food above 40 degrees is a crime in itself. So B is guilty, and he also lost his coat that day. Bad day for B. The entrapment defense. The entrapment defense asserts that the police improperly and illegally induced the defendant to commit the crime. Entrapment involves excessive or unfair inducements, encouragements, that are capable of inducing a person not predisposed to commit a crime to do so. Now, inducements are excessive or unfair, and thus trigger the entrapment defense, when they are excessive in number. The police keep hounding the same person. They appeal to the defendant's sense of mercy, or they offer unreasonable profit, or the police trick the defendant into thinking an illegal act is legal. Let's look at these one at a time. An inducement is excessive if it's excessive in number. If I'm an undercover cop and I think that Joe is a drug dealer, So I dress up like a drug addict and I walk up to him on the street and I say, hey man, I want to score some heroin. Have you got any? And he says, no, I'm not selling heroin. And I go away and I come back 2 hours later. Hey, you got some heroin now? Will you sell it to me? Come on. And he goes, no. And then I come back the next day and I ask him again and he says no. And I come back later that day, he says no. Well, at some point, he may turn around and just sell me heroin, not because he's a dealer, but because he uses too and he has the drugs and I'm just a pain in the butt and he wants to get rid of me. At some point, the number of requests to commit a crime become excessive and they would trigger an entrapment defense that the person finally gave in and sold you the drugs or did whatever criminal act you were trying to get him to do. Inducements are unfair when they appeal to the defendant's sense of mercy. Let's take the same situation, but this time I'm the undercover cop and I go after the suspected drug pusher and I say, hey man, I'm addicted to heroin and I'm really strung out. I haven't had a fix in 2 days. I'm going through withdrawal. I'm really in pain, man. Please, could you sell me some drugs, some heroin? And he did. He probably could use the entrapment defense because I appealed to his sense of mercy. He might not have been a person predisposed to selling drugs. He might have been a drug user who knows how bad it is to be in withdrawal because maybe he or she went through it in the past and maybe selling me the drugs not for the profit of a drug dealer, but because he feels sorry for me and wants to help. That would be a appeal to the defendant's sense of mercy. We don't know if we have a mean, profit-making drug dealer or just a nice person trying to help a strung-out addict. So that would be a case where they could, the person could claim he or she was entrapped because the officer appealed to the sense of mercy. Inducements are also unfair if they offer unreasonable profit. Let's take the same situation. I'm an undercover cop and I think this guy's a drug dealer. So I rent a limousine and I dress up in really expensive clothing and I have another cop pretending to be my chauffeur. And I pull up to the corner where this person I think is a drug dealer is selling drugs. And I roll down the window and I say, my good man, I've heard that you have some drug called crack cocaine, and I would so much like to try it. I have $500. Would that buy me a vial? Well, obviously, that's an unreasonable profit. Crack cocaine usually goes for $5 or $10 a vial. You're offering 100 times that amount, potentially. That could cause a person who has crack cocaine, who uses it, but is not predisposed to selling because of the outrageous profit to sell the drug to you. And if they did sell it to you and you lock them up, they'd have a pretty good shot at an entrapment defense due to an excessive inducement. And finally, inducements are unfair if they trick the defendant into thinking an illegal act is legal. If you had a defendant who wasn't too bright and you're an undercover cop, and you lie to that person and tell him that delivering these drugs is not illegal, and then you give him drugs and halfway through the delivery you have your other cops lock him up. Well, you tricked that defendant into thinking an illegal act is legal, and if you arrested him or her for it, then they could claim the entrapment defense. And by the way, denying one is a police officer when one is asked or asking someone to commit a crime, they are not entrapment. If an undercover cop is undercover and a criminal says, hey, are you a cop? And the cop lies and say, no, I'm not a cop, that's not entrapment. You could never do undercover work if cops were expected to tell the truth when asked if they're undercover cops. Law enforcement would be impossible. And besides, lying and telling people that you're not a cop is not excessive or unfair in any way. In addition, asking someone to commit a crime is not entrapment. Undercover cops do buy and bust all the time. Walk up to drug dealers. Hey man, pretending to be a drug addict, dressed like one, you sell me some drugs. Or pretending to be a John, somebody who wants to hire a prostitute, walking up to a woman who looks like a prostitute on the street and saying, hey, how about some money for sex? I mean, I use better language than that, but this is a course. Asking someone to commit a crime is not entrapment. Remember, it's only entrapment if the police use excessive or unfair inducements. Right? That's entrapment. And that's the entrapment defense, and that's the end of this lesson.